Hi, everyone. Good morning. Today we will be covering some updates to the open meetings law and some more general topics that we get a lot of questions on regarding open meetings and public comment and that sort of stuff. Unfortunately, Jen Swartzout, who was supposed to be presenting with me, couldn't make it this morning, so you're stuck with me instead. Okay, Kathy, you can tab to the next slide. So like I said, today we're going to be covering just an overview of the open meetings law, the new posting requirements, public comment, virtual meetings, and executive sessions. Okay. So generally, the open meetings law requires that most things be discussed and acted on in public session for public bodies. Topics may be controversial or politically charged, but that doesn't give a public body the right to discuss them behind closed doors. Everything has to be open and discussed in the public eye. This doesn't apply just to voting. It also applies to any activity preliminary to a vote or consideration of a matter that could be the subject of board action, and that is a very, very broad gamut of topics that can be considered on the subject of a board action. Work sessions and committee meetings generally are considered to be public meetings, so that would require public notice of all covered meetings. Virtual meetings, we'll talk about this a little bit later, have some of their own quirks that you have to be wary of before you allow those to go forward. Okay, next slide. Open meetings law doesn't usually apply to chance encounters. However, if this chance encounter turns into an informal conference or an agenda session, the courts have said that that would be considered a meeting of a public body. It also doesn't usually apply to board retreats. We actually get quite a few questions about this. Board retreats are not subject to the open meetings law, but just because you call it a retreat doesn't insulate it from the requirements of the open meetings law. If the gathering is not for the purpose of conducting public business, but rather it's for education, training, team building, developing communication skills, considering interpersonal relationships, this wouldn't be considered a meeting of a public body subject to the open meetings law. However, if any specific board business to discuss at the meeting, if anything besides generalized training occurs, then it would be subject to the open meetings law and require public notice. We also get a lot of questions about board members attending meetings of other groups, like the PTA, for example, or a municipal board meeting. The answer to whether it's a meeting that's subject to the open meetings law is what's expected of the board members when they're there, whether they're expected to conduct board business or if they're just there as a private citizen, really makes the difference. Board members are people too and are allowed to attend meetings other than the board without triggering the open meetings law and requiring notice. Okay. Committee and subcommittee meetings generally are subject to the open meetings law. These are meetings at which members meet to conduct public business, much like a general board meeting. These committee and subcommittee meetings I'm talking about are the ones that are populated by board members exclusively, or when board members make up the majority of the committee. Advisory committee meetings generally are not subject to the open meetings law and don't require you to allow the public to attend and don't require you to provide notice of the meetings unless the advisory committee is only made up of board members or it performs a governmental function. Determining whether it's a governmental function is fact specific. When these cases come up, the court usually will undertake an analysis that centers on the authority under which the entity was created, the power distribution or sharing model under which it exists, the nature of its role, the power it possesses and under which it purports to act, and a realistic appraisal of its functional relationship to affected parties and constituencies. In other words, who approved it, what are they supposed to do, and does it impact the board as a whole and their decision making? So if an advisory committee is made up of 4 board members exclusively and they're discussing board business and they make a recommendation to the board, which is then voted on by the board, yeah, that would be considered a governmental function. Similarly, shared decision-making committees, especially the ones that are required under the commissioner's regulations, those are subject to the open meetings law. So it doesn't matter how many board members attend those meetings, whether there's a quorum of board members or not, regardless of their attendance, those always have to be noticed and open to the public. Okay, next slide. Okay, what is proper notice? Meetings have to be scheduled at least one week in advance, and notice must be given to the news media in one or more designated public locations at least 72 hours prior to the meeting. For meetings that are scheduled less than a week in advance, an emergency meeting or a special meeting, you have to give notice of the time and place of the meeting to the media and publicly post it a reasonable time before the meeting. For example, it's been said that if you decide to have a meeting on a Friday and you post the notice of the meeting on the school bulletin board, but the school is locked up for the weekend and nobody can see it, that wouldn't be considered reasonable notice for that meeting. The regulations still read that if you have a website, you have to post it on there too. I think everyone has a website at this point, so you should always just plan on posting the notice on the website as well. Okay. Which meetings are exempt from the public notice requirement? Exempt meetings don't have to be conducted in public and they don't have to be noticed. These would be judicial or quasi-judicial proceedings and any matter made confidential by federal or state law. An example of an exempt meeting regarding a matter made confidential by a federal law is a meeting to discuss student records or information obtained from those records. This would be made confidential by the Family Educational Rights and Privacy Act, FERPA, which would prohibit school officials from divulging without parental consent education records that are identifiable to a particular student or students. So in other words, if confidential student information will be discussed, this can only occur in an exempt session and the public is not invited to attend those. An example of a quasi-judicial proceeding would be a review by the Board of Education of a student disciplinary appeal, a civil service Section 75 hearing, things like that. And an example of an exempt meeting regarding a matter made confidential by state law would be a meeting between the board and the board's attorney to discuss upcoming litigation. This would be protected by attorney-client privilege, which is pursuant to New York civil practice law rules. Okay, you can go to the next slide. Okay, so there were some updates last year to the open meetings law. One in particular that affects a lot of our boards is the requirement that now all the documents that will be acted on or considered by the school district's Board of Education have to be made available 24 hours before the meeting. So this would be any contracts, anything at all that, papered or electronic that the board is going to be discussing or approving. You have to make that publicly available. Best practices is probably putting it up on the website along with the agenda. You can make it part of the agenda. And while there's no legal requirement that an agenda be posted, this seems to be the easiest way to do that, is to put these all into one document. Okay. You also have to start minutes have to be posted online within 2 weeks of your regularly scheduled meetings and within 1 week of an executive session. We'll talk about the need for minutes at an executive session a bit later. Acceptable minutes are unabridged video and audio recordings or unabridged transcripts. Minutes do not need to be approved before they're disseminated. I know a lot of boards like to approve their minutes, so just make sure that you're doing that within 2 weeks of the meeting so that they can be posted online. If not, an unapproved version of the minutes will have to be put up. Yeah, there's no mandate that minutes be prepared during an executive session unless formal action is taken. And that is really there's only really one exception that comes up for that, and that's voting on probable cause for a 3020A teacher discipline action. That's really the only action a board is allowed to take during executive session. There's various interpretations of Education Law 1708 that stand for the proposition that, except in situations in which action during a closed session is required by statute, school boards generally are legally prohibited from taking action during an executive session because everything needs to be voted on in the public. So that's why minutes don't need to be prepared, because there's no action taken. Okay. I'll discuss some issues with public comment periods. I know that we have received a lot of questions about this with the contentious nature of the past couple of years and board meetings. Under the law, you don't have to let the public comment at your board meetings. It's strongly encouraged by the Committee on Open Government, but there is no requirement. Your meeting just has to be in public. You don't have to allow public participation. Most boards do choose to do that anyway, because it's a good practice to have, open communication with their constituents. Boards can adopt policies that set forth reasonable expectations for participation in public comment. There's been a lot of case law about this recently, about what is reasonable and what is not. You can have conduct expectations. You can move the slide, Kathy. You can set limits on participation, both for individual comments and for the entire period. For example, you could limit speaking time to 3 minutes per person, and the entire public participation block could be limited to 30 minutes or an hour, depending on, how many speakers you usually have. All of these things should be set forth, absolutely written out and explicit in a board policy. You can limit the topics to be discussed. You can prohibit student and personnel related topics. But the thing is, if you do that, you have to be content neutral about it. You can't allow someone to, you can't have a blanket on disparaging personnel, but allow for complimenting personnel. While there isn't really a lot of cases where, somebody has brought that up, but that's been hinted at in the case law, that when you have these kind of prohibitions, they have to be on both sides. You can install protocols for public comment. You can require people to sign up in advance. You can require speakers to only address the presiding officer of the board rather than addressing individual board members. This can limit the amount of, yelling and harassment that individual board members have to take sometimes when people are really fired up. You can establish consequences for failure to follow the rules. So you can prevent a person from speaking again. You can have a policy in place that prevents people from speaking at back-to-back meetings. You can say, you had your chance to speak at this one, you cannot speak at the next one. But again, that has to be outlined in your board policy. You cannot engage in viewpoint discrimination. Like I said earlier, you can't, only allow people on one side of an issue to talk and then not allow the other side of the issue to talk. But you also can't censor speech just because it's offensive to some. which is a very subjective point of view. But the courts have, that's from a Supreme Court decision. I mean, you can, you know, if somebody's swearing and yelling and harassing and being really, you know, nasty to somebody, you can ask them to leave the meeting. That's not disallowed. You can also prohibit individuals from yielding their time to others. So that happens sometimes when you have the 3-minute rule and you get a group of people together that want to skirt that rule. So, you know, 8 people will sign up and they'll all yield their time to one person so that that person can yell at the board for 20 minutes. That is an acceptable practice, is to have that. But again, it has to be in your board policy. You can also restrict repetitive comments. If, you know, 5 people sign up to talk about the same side of one subject, you can have, you can restrict it to only allowing one of them to speak. You can require people to have to pre-register in person prior to the meeting, and I believe the reasonable time on that was 2 days. You can require that because it's been found that that's not substantially more burdensome than necessary, and it gives the board a realistic idea of who really intends to talk, rather than you know, signing up online and then not showing up. So the courts have okayed that. Okay, next one. Okay, now there have been some real changes made to how virtual meetings are handled, whether they're allowed, how, whether you have to allow people to show up at anybody's house to be able to participate. So I'm just going to do a quick recap of the history of the virtual meetings in New York. So pre-COVID, so pre-2020 March, virtual meetings were only authorized under very strict conditions. You had to provide notice to the public of the location of the virtual participant, and that location had to be accessible to the public. So like I said, somebody is home sick and wants to participate by video conference, you have to put their address up there, and you have to let the public participate at that location should they so choose, which wasn't a really realistic option for most organizations. In March of 2020, Governor Cuomo authorized remote meetings during the COVID pandemic under relaxed conditions. The requirements for this were that the meetings had to be recorded, they had to be transcribed, and you had to allow video or telephone participation by the public. Next slide. Okay, so then in July of 2020, from July of 2021 to September of 2021, the state of emergency was lifted, and therefore it reverted back to the original rules with the having to provide location of all the members, et cetera. And then Governor Hochul then filed her executive order with issuing a state of emergency as well in September. So from September 2021 to April of 2022, the legislature amended the open meetings law to provide that virtual participation was permitted while the ongoing state of emergency was in effect. So up until that executive order expired or was not renewed anymore, they allowed virtual meetings to go on under the rules that Governor Cuomo had initially set forth in his executive order in March of 2020. However, last month, the 2022 budget bill was released, and this has some new rules for virtual meetings. Boards can allow virtual participation under the COVID rules up through the executive order with the state of emergency that's set to expire June 8th. Has to be transcribed, has to be recorded, and have to allow public video or telephone participation. So after June 8th, going from June 8th of this year on towards July 1st of 2024, boards will have 2 options to participate virtually in board meetings. Next slide. Option number 1 is using the old rules. Video conferencing only. Telephone participation is not allowed. You can't vote by telephone. Board members can participate virtually if the public's allowed to attend in person wherever the board member happens to be. And notice of the board member's location has to be provided in the meeting notice. That was also something that was suspended during the rules under COVID, was that you didn't have to provide the board members, home address or the location where they were. Now, option 2 are these new remote participation rules. Boards of education can use video conferencing without in-person attendance at the location of the member participating by video conference under some new conditions. So these new conditions are that there must be at least, you can move this slide. There must be at least one physical location where members of the public can attend in person. So these rules are basically when 1 or 2 people can attend, but the rest of the board is meeting at the normal location and in person. A quorum has to be physically present at this physical location to allow for the other members to participate virtually. The board has to pass a resolution to allow for this, and has to write written procedures and post them on its website. Board member participation is only allowed virtually if the member is physically unable to be present because of extraordinary circumstances. This includes in the budget bill, these 3 are specifically listed: disability, illness, or caregiving responsibilities. But then there's the grouping of any other significant or unexpected factor or event which precludes physical attendance. This has to be defined in the procedures, and I'll get to that in just a second. So members participating by video conference have to be seen, heard, and identified at all times except during an executive session. If a member is participating virtually, the public also has to be allowed to participate via video conference in real time and in the same capacity as those who attend in person. So you can't give favoritism you can't show any sort of favoritism or any special allowances for the people that attend in person versus the people who are participating virtually. The minutes also have to reflect which members participated virtually. And it has to be noticed in the public notice that video conferencing will be used. That's to give people notice that they can also participate virtually. The video conference meeting has to be recorded, and the recording has to be put on your website within 5 days of the meeting. So that's a new rule too. And the technology used to do the video conference has to be ADA compliant, which basically means it has to be capable of providing closed captioning. Okay. So the in-person requirements under this new law do not apply during a state of emergency. That allows that if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting, then they can just hold it virtually like under the old COVID rules. So they don't have to, the board does not have to have a physical location, and they do not have to have a quorum meeting at a physical location, and they do not have to allow the public to participate in person if there is a state of emergency declared, when that's whether it's national, state, or local. So if your location is having a huge, terrible outbreak in your local Department of Health declares a state of emergency, you would be allowed to hold virtual meetings again. Okay, the Committee on Open Government has issued some guidance on this new system under the budget bill. And so before you utilize option 2, there are 3 things that have to happen. You have to hold a public hearing on the matter. So you have to have input on whether you want to be allowed to have your members participate virtually. You also have to pass a resolution that allows for such hybrid meetings. And you have to develop written procedures for the virtual meetings, and these have to be exhibited on the district's website. These can be as basic or as complex as you'd like them to be. The one thing that these procedures do have to include is a definition for the extraordinary circumstances that would allow for virtual participation. This would include everything that the board deems an acceptable excuse. You could choose to loosely define it and, just allow for, any type of an emergency that comes up to be allowed, or you could limit it to something as specific as, attending a funeral out of location or anything else like that. But illness, disability, and caregiver duties are already included in the allowable excuses in the budget bill. Okay, we're also going to just talk a little bit about executive sessions. We get a lot of questions about that, so we thought we'd do a little bit of an overview on that. And I do want to distinguish between an exempt session and an executive session. An exempt session is completely exempt from the open meetings law, whereas an executive session is a portion of the school board meeting that's not open to the public. Executive sessions can only take place upon a majority vote of the total membership of the board taken at the open meeting. The motion should specify the subject or subjects to be discussed, and executive sessions are permitted only for discussion about the above subjects, and those are matters that would imperil public safety if discussed openly, identity of law enforcement agent or an informant, current or future criminal investigation, proposed or pending litigation, collective bargaining, the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation, preparation, grading, or administration of exams, and property sales or sales acquisition of bonds if publicity would substantially affect the value. The motion to go into an executive session has to specify the subject. You can't just reiterate the statutory language verbatim. That's that's a no-no from the Committee on Open Government. They have also consistently held that simply stating you're going into executive session to discuss personnel matters isn't sufficient. The widely acknowledged personnel exception only applies to certain specific issues related to employment. So you would have to, be a little bit more elaborate in what you're going to be discussing rather than just saying personnel matters. So the medical, financial, credit, employment history, appointment, we want to discuss the promotion of a teacher. We want to discuss the promotion of an administrator. That type of thing would be more appropriate. Like we discussed before, voting cannot occur in executive sessions with the one exception, which is that when a school board votes on whether to prefer disciplinary charges against a tenured teacher or educator under 3020A, that vote takes place in executive session rather than in public. There's one case that's a pretty good cautionary tale where the board met with its attorney and decided to appeal an adverse commissioner's decision, but never voted on the action in public. And the appellate court annulled the decision to take the appeal because that vote never occurred in public. So when you're considering anything, make sure you do the vote in public, or else it might get reversed or nullified. Okay, who can attend an executive session? They can be attended by any member of the Board of Education as well as any other person authorized by the board to attend. In large and small city school districts, the law gives the superintendent a seat on the board and the right to speak on all matters, but not to vote. So the superintendent in those types of districts also has the right to attend any executive session. Boards don't have to allow parents or their counsel to They'll listen to executive sessions when they're considering student disciplinary appeals. They do not have that right. And any guest which a board may invite into executive session doesn't have to be identified in the motion to enter or in the minutes, which may be taken, but again, most times minutes don't need to be taken during executive sessions. There is an exception to when a board member might not be allowed to attend an executive session, and that would be when the board member is maybe suing the board or suing the school. Under which case they would be acting on their own initiative rather than in the schools on behalf of the school. So they can be barred from attending a board's executive session under that situation. Executive sessions, there is a duty of confidentiality imposed on board members when you're in an executive session. And there are penalties for that if you break that confidentiality. There's 2 commissioners' decisions that have established that release of confidential information is a violation of a board member's duty, and that it can constitute official misconduct and warrant removal from the board. So you definitely want to be clear that you do not want to, release any of the information that you learn in an executive session. If you remember recently, the Buffalo School Board had an issue with this as well, with Carl Palladino. That was how he was removed from that board, was because he was found liable for disclosing confidential information he learned in an executive session. The rationale behind that is that by a single board member releasing information learned in an executive session, it's thwarting the will of the majority of the board and invalidating its actions. The release of information in an executive session should and is only allowed to be released by a majority vote of the board. Because again, that when you're a board member, you're acting on behalf of the school and on behalf of the board rather than your own individual, and individual board members are not allowed to act on their own. Unauthorized disclosure of executive session information is a breach of a fiduciary duty to the district. And matters that are discussed in executive session are confidential for the purposes of general municipal law. Okay, just a quick thing on minutes. Minutes don't have to be taken in executive session, but when you are voting on charges under 3020A, you do need to take minutes. So that is the one exception to that, where minutes actually have to be taken. So looks like we're finishing up a little early. So if anybody has any questions, I would be happy to answer them now, or if you have any questions after, just shoot me an email and I will be sure to get back to you as soon as I can.
Kristen, I'm not seeing any questions in the chat or the Q&A. I just like to ask everyone to remember to take our survey once we close out the webinar.
All right, well, thank you for spending the morning. Enjoy the rest of your day.